happy to continue to to really continue this conversation that we're just having now, and take it in a very different direction. We're now going to have Margaret Peters from the Department of Political Science in UCLA and Tiana Lujic from the Institute of Political Science in Heidelberg University discuss informalization, obfuscation, and bilateral labor agreements. And the discussant is going to be Janie Twang from American University, Washington College of Law. So Maggie and Tiana, the floor is yours. Tamar, did you make them hosts? Do I need to?
I will.
Okay, thank you.
Okay, great. Can I share screen?
Can I share a screen? Yes.
In 1 minute.
Making you
Okay.
able to share screen.
Okay.
Okay, let me just get it started then. Okay, so first of all, I think this will be a really good kind of continuation as both the piece by Tamar and then by Maggie and I speak to each other, and even like just reading it and hearing your presentation, some kind of questions on our paper kind of came up for me in our coding. So I'll be presenting the working paper titled Informalization, Obfuscation, and Bilateral Labor Agreements. So we started thinking about the topic because we considered that there's no real distinct database or online repository where one could find BLAs. The accessibility of the agreements in other areas of international cooperation, for example, investment treaties, is higher, and that several researchers and scholars who have compiled lists of BLAs have noted that some are harder to find than others. The question kind of automatically popped up, why is it harder to find out information on some bilateral labor agreements than others? Based on research on informalization and obfuscation in international relations primarily, we would expect that policymakers use more informal agreements and make it more difficult to find information on BLAs when they think they will be politically unpopular and unlikely to be ratified. In this case, governments should turn to strategies of obfuscation, and informal agreements should be more likely. To test this idea, we built a new data set of the ease of finding data on BLAs. Using Maggie Peters' data set as our list of BLAs, we create several measures on how easy it is to find data on these agreements. So we code for the type of agreement, information found, and if and how easily it is to find the agreement text. Basically, we divided the analyses into two sets of hypotheses. The first one's on the formality of the agreements, and the second one's on the accessibility of the information. So theoretically, states turn to informality as it provides more flexibility and more speed. Informality does not require the precision or the level of obligation that formal agreements do. It has lower transaction costs. States don't have to ratify the agreement, making it quicker to put into place. By bypassing ratification, states also reduce the number of veto players that are needed to put the agreement in place. All in all, the benefits of informality, kind of speaking to the previous paper, because of these benefits, in international relations literature, recent international relations literature, authors have found that formal institutions have tended to stagnate, and informal institutions and agreements are rising, or there's a trend towards informalization. And in addition, literature has spoken also on certain regions of the globe being more prone to informality. So for example, as we've heard also previously, Asia being more prone to cooperate informally than other regions. As such, our hypotheses then are that formality is more likely when there are fewer veto players in a state. And for this, we use explanatory variables containing political constraints. then that formality is more likely when support for immigration is higher. Here we use the percentage of the far right, as well as unemployment and unemployment in the receiving state, as well as economic growth in the sending state. Then when policymakers want to lock in immigration policy openness, here we use the regime type, as well as, I can't remember, but we could get back to that. And then the next one is that there is more certainty of future support for immigration and few fears of backlash. Here we use indicators of a shared language, same colonial system, as well as a higher level of education of the immigrants from the sending state. And then we expect formality to be higher in the past, as I've already mentioned, and higher when a country is not in Asia, or the receiving country is not in Asia. In addition to formality, we have a set of hypotheses that look at accessibility. Here, it's kind of worth noting that we use accessibility instead of obfuscation, because we believe that obfuscation is hard to quantitatively capture because it has an aspect of intentionality we can't really look at. So we're kind of trying to look at how informality and accessibility speak to each other and may make plausible that states seek to obfuscate. So especially because immigration policy is such a salient issue for voters and domestic audiences, we expect that there is an incentive for states to obfuscate what they're doing as to avoid potential popular backlash. Usually agreement texts, especially if they require ratification, should be made available under a treaty depository, which may be held by one of the state signatories or by an international organization. Mostly this is the UN. However, if the type of agreement is labeled less formal, states have no requirement to do so. We see this mostly with political arrangements and MOUs. Theoretically here, we kind of build on Kono's concept of optimal obfuscation for our accessibility hypotheses. This can be understood as an extreme strategy for securing political survival. So Kono posits that democracies, rather than exhibiting higher levels of policy transparency, actually tend to obscure policies when a specific issue area is unpopular domestically with domestic audiences. So he contends that democracies especially have more incentives to do so because their political system generates open political competition and voter information. Now, in our view, we kind of diverge from this and think or hypothesize that there is little difference between democratic and autocratic forms of or modes for political survival, as while democratic modes of political survival may rely more heavily on voter satisfaction, autocracies also have an incentive to obfuscate as to legitimize their rule to their winning coalition or even the mass public when it's a civilian-controlled autocracy. So as such, the following hypothesis kind of came from this theoretical reading, and democracies and civilian autocracies should use informal agreements more than military or personalist dictatorships. Accessibility should be higher when immigration is more popular, and that there will be no difference between regime types, as both, as I mentioned, democracies and autocracies have an incentive to obfuscate, but for different reasons. Now, before I kind of dive into our analysis and the results that we found, first a few words on how we operationalized informality and accessibility. And I think this is also a good kind of connection to the paper we heard beforehand, because especially due to the formality part of the coding that we did. So here we basically looked at the type of agreement, and we looked at the agreement title, where we could find it. Now, we're completely aware that the line and the distinction is often blurry, and you can't really say, is it a treaty or is it a less formal mean of cooperation between states? But we coded the title because we expected that the naming of a treaty itself is a subjective act and actually points towards the political considerations that the signatories may have had concluding it. Now, there's also probably a cultural thing within it. France tends to name their treaties different than the US does, but as a rule or as to make a distinction, we looked at the title, especially considering that most of the agreements we have on our list, the agreement text was hard to find or couldn't be found at all. So from this, we looked at for formal agreements, bilateral treaties and protocols, and then for informal, when the treaty or the agreement was labeled as an arrangement, a framework agreement, exchange of letters or notes, whereby here we kind of looked at if it said exchange of letters constituting an agreement, we coded it as a bilateral treaty, and if that wording was missing, we coded it as an exchange of letters solely, and then memoranda of understanding. For the measures for accessibility, on the other hand, we had two measures that we looked at. So the minutes that it took us to find an agreement text via Google search. And here we gave ourselves 10 minutes to find it. If we could not find it within this scope, we label it as could not be found. But in addition to this, we also looked at the sources of information that we could find. So if there's speeches from executive bodies, political representatives on the treaty, press releases, of course, if we could find the agreement text or not, and then also research on the topic. And research on the topic specifically because we couldn't go to archives and actually look if we could find the agreement text there, as to kind of substitute that missing part from a Google search. From these two measures, we made then 3 variables. So here we have then the ease of access, which is the minutes it took us to find it, the text found or not, and then the number of sources of information. And from the formality part, we took the formality of agreement. We then run a regression on our 4 variables. And while these variables are dichotomous, we follow the standard and use an ordinary least squares regression. The results are the following. So overall, we could see a rise in informality over time, especially after 1996. There is no statistically significant effect of veto players that we could find on informality. Then when immigration is likely to be unpopular, informality is higher. We find little support for the idea that states use formal agreements to lock in the immigration policy change. For example, personalists are more likely to use informal agreements in democracies, less so. Then there's some support for concerns about a backlash. And interestingly, we find some regional variation, but not what we would expect. So actually, North America, in which Canada has the most of these agreements, seems to have a greater propensity for signing informal agreements than the rest of the world. These trends in informality correspond with our results on accessibility of the information. So both the accessibility of the text and the number of sources on an agreement exhibit a downward trend as well. Considering that the percentage of votes for the far-right parties in the receiving state has a negative impact on the accessibility of agreements, as well as on all accessibility variables, we believe that expected backlash from signing a BLA ultimately may explain this downward trend. And then, contrary to our expectations, both formality and accessibility of the agreement texts is overall higher in democracies than in autocracies. But there is no difference between different types of autocracies. So if it's personal, military, etc. And then finally, we find some support for the idea that it's harder to find information on BLAs when immigration is unpopular and migrants from a particular sending state are perceived to be culturally different. We find more information on agreements when migrants are from the same colonial system, share a language, and have a higher level of education overall. Again, institutional effects. Well, here for institutional effects, we found some evidence that they may have an impact, but it was all in all inconclusive. We do see a slight trend towards more or less accessibility where these institutional effects are higher. So there's more veto players and political constraints.
Anna, if you can wrap up.
Yeah, I'm
oh, wonderful.
Sum up. So we still have to flesh out our conclusion, but from what I just kind of outlined from our results, informalization increased over time, information is less accessible over time, and the most recent agreements are the hardest to find. And then informal agreements are signed when immigration is unpopular, and as well, the same applies to the accessibility of information. And the interesting part was that the institutional effects, such as veto players and executive constraints, only slightly impacted informality. Well, informality not at all, but accessibility of the information. Kind of looking at these results all together, also the ones that I highlighted previously, we assume that this kind of points towards informalization and obfuscation as recent trends and phenomena that are in need of further specification in the case of maybe longitudinal case studies where we could look into why certain governments at certain points in time choose to obfuscate or not, or just maybe, as we've previously commented, too lazy to upload an agreement text. Thank you, and I'm looking forward to this discussion.
Thank you very much, Tiana and Maggie, for this really, really rich and interesting presentation that brings a lot of kind of new ideas, I think, into the table about what's happening here. Our discussant is going to be Janie Tran from American University, Washington College of Law. Thank you so much, Janie, for being with us here, and the floor is yours.
Thank you so much for having me. I loved this paper. It was so rich and there were so many ideas in it. And I found myself asking, what if, why at almost every turn and with every paragraph. And so I guess that's all to say that it's such a great paper in the range of different hypotheses that have been thrown out. And my reaction to it was just to ask just to have so many more questions, right? And so I hope that's a helpful response. I also want to add the caveat that I come at this as somebody who is a scholar of international law and institutions. I'm not a political scientist, and I have to confess up front, I don't know how to read a regression analysis. So I apologize if some of my comments come from a place of disciplinary ignorance. So I really am coming at this sideways. So apologies in advance in case my questions and suggestions point you in a direction that are beyond the scope of your project or beyond the scope of your methodology. So apologies in advance. Okay, so I thought I'd just launch right into my questions in the interest of time rather than recap what you did, which you did so beautifully in your presentation. So a couple of questions, and some of them sort of were raised or these issues came up in response to Tamar's presentation. So the first question around informality, I found myself wondering what you meant by informality. You defined informality in international law. You mentioned soft law, informal governance, informal intergovernmental organizations. And I guess and then in your presentation, you had a sort of list of what was considered formal and what was considered informal that I don't think was in the paper, so maybe merging the two. And this came up in Tamar's, I think, presentation, which is, are you defining informality by non-bindingness, right? Because you mentioned soft law, which is technically non-binding as a key characteristic. And so are you, I guess I'm a little confused about the categories, right? How much is non-bindingness a necessary feature of informality? You mentioned that informality doesn't require precision, and I guess when I read that, I thought, well, sometimes informality allows for more precision. In international law, we sort of think, well, part of the turn to soft law is that allows for states to be more specific in their obligations, and that they can afford to be because it's non-binding, right? They don't have to make these commitments, so there's less to lose in being precise. Whereas in treaty making processes, we're looking for the lowest common denominator, right? And so I wanted to ask you about whether or not it's necessarily the case that informality allows for greater precision, or informality allows for less precision. My tendency is to think it's the opposite direction. And then what do you mean by treaties? Because the language you use throughout the paper, you mentioned treaties, you mentioned informal treaties, and this takes me back to the point Tamara raised in terms of the definition of treaty, right? Under the Vienna Convention on the Law of Treaties, VCLT, Article 2. Do you have a broader concept of what a treaty is than that which is contained in the VCLT, notwithstanding Tamar's expansive view of what a treaty entails, right? And you mentioned that there is a line between treaties and other bilateral agreements that's often hard to distinguish. And I wondered if you might say a little bit more about that, because again, I wasn't sure what your categories were. And that relates to accessibility. So on the accessibility point, I think the paper alludes to trying to access these instruments, that it's harder to access informal agreements than treaties. And I guess one question I have about that is, isn't that by design? When you talk about the UN treaty database, and this is a question I don't know the answer to, I'm not sure what's included in the UN treaty database, whether or not it hews to the definition of what's covered by the VCLT, because at least the traditional view of how you interpret what technically is a treaty, and this might affect what goes in the database, right? Is that treaties are a subset, kind of a narrow subset of international agreements that might be out there, whether because the agreements are actually governed by domestic laws, or they name domestic laws as the governing law. So you might have international agreements between two states, but they apply domestic laws of either state rather than international law, which takes them out of the technical form of treaty, right? And so those sorts of agreements might then not go into the UN treaty database if the UN treaty database is, hews to the definition of treaty under the VCLT. So I guess that's kind of a technical question. And you mentioned trying to access information from the IOM. In the beginning of the paper, you mentioned how IOM doesn't contain information on many bilateral labor agreements signed by states. I wonder how much of that inaccessibility might be attributable to IOM's structure and its operations. It's so decentralized. It has a tiny headquarters office. IOM is kind of known for its secrecy. It's very hard to research information at the IOM. They don't have you can't walk into a room and search their archives, right? It's one of these institutions where you have to go in and say, I need document number X in order to access it. And so I say this because I'm a part of a group of scholars who are trying to look at IOM, and the constant refrain in our meetings is that it's so hard to get access to information from IOM because of IOM's decentralized structure, and because it's kind of a secretive organization in terms of just its operations. So I wonder if it might be worth acknowledging sort of those background constraints in terms of accessibility. The other piece of accessibility you mentioned was Google searches. And I guess I wonder, how neutral are Google's, right? In terms of the availability that comes of information that comes across when you search for something on Google, how neutral is it, right? Are there built-in biases such that certain types of information from certain regions of the world are more likely to come up than others? And I don't know the answer to the question, but I thought it might be worth acknowledging that that might be an issue. And if it's not, then saying that it's not an issue, right? And then I had a question. So those were kind of specific questions. And then I had a set of kind of broader questions about framing. So your conclusions are framed in terms of that there's greater informality and these instruments are less accessible as immigration becomes more unpopular. And I was wondering if you had tested the reverse, right? In that, I guess the question is, when is immigration ever popular, right? And do you have sort of a correlation that shows that actually, in these particular instances, immigration is popular, and what we see is that there's more transparency, less secrecy, less obfuscation. I didn't see that in the paper, so I wasn't sure what you had as the comparison, right? There was just sort of information about immigration becoming more unpopular, and I thought it would strengthen it if you could point to the opposite, right? You do suggest, I think, in the paper that for sending countries, politicians might want to publicize and formalize BLAs. But I was wondering if you had tested that hypothesis, right? Because that would help to show that, when it is more popular, there actually is sort of less secrecy or more accessibility to those instruments. So I guess that was one sort of broader question of, in order to show that there's more or the less accessibility and more informality when immigration is less popular, do you have to maybe show the reverse effect, right? To really prove that. And then the other question that came up for me was about the narrative of the desire to obfuscate. You said that it's hard to measure that, and so you're measuring it through accessibility. Because when I think about migration, and when I first read your paper and the title, I thought, well, of course it's going to be inaccessible and informal because of sovereignty, right? Migration as the last bastion of sovereignty, people talk about that. And when you think about the field of international migration law, it's so dominated, right? If you took all the laws that dealt with cross-border migration, at least in the multilateral treaty context, it'd be overwhelmingly dominated by laws dealing with asylum and refugees, right? And that the universe of economic migration related instruments is so small, and the few treaties we have are poorly ratified, and to the extent that they are ratified, they tend to be overwhelmingly by countries of origin rather than countries of destination. So it's an area where there's just not a lot of law, right? And so I wonder, and people attribute that to sovereignty, right? And states being really unwilling to enter into any sort of international commitments around migration, and also that's reflected in the lack of international institutions that have been recognized to be the sort of lead organization on migration until very recently, with IOM's elevation to, kind of the lead of the UN Migration Network under the GCM. And so I just wonder how much of that narrative around migration as the last bastion of sovereignty, and maybe that's kind of, I wonder how much of that narrative, where does that fit with respect to your thesis about, or your hypothesis about obfuscation, right? Is obfuscation more of an incentive than this sort of background dynamic of maybe countries just don't want to touch migration, that there's a background sort of disincentive to engage in international agreements on migration, in part because, one could point to, I think, Elah's paper and this idea of a control thesis, like maybe countries don't enter into these agreements, not so much because they're unpopular, but because there's just kind of a built-in incentive towards informality and secrecy because of control, right? That governments may not want to commit to a set of protections or opportunities for, say, temporary guest workers, so that they can thereby preserve maximum ability to adjust based on whatever their labor market needs might be. And so I guess the bottom line is, how much do you weigh that desire to obfuscate against this sort of background sense that countries just don't want to enter into these agreements in the first place, or that feeds into the lack of accessibility and the more informal nature. So those were kind of my questions. I hope that they're not totally far afield, but I thought it was a really rich paper, and I had a dozen more questions, but those were kind of the main ones that struck me as would be as possibly useful to maybe address, so as to sharpen your conclusions and to sort of bat down the sort of what ifs as questioning some of the hypotheses.
Thank you very much, Janie. So Maggie and Tiana, would you like to first respond, then we'll take open it up?
Sure. I'll have a couple thoughts, and then Tiana, if you want to jump in. I'm going to kind of go backwards. So what about the control thesis? I agree that this is an area where states don't really want to give up control, but then the question goes, so I come from a background of international political economy where we think a lot about trade and investment. So like, why are states willing to give up control in those areas? So like, what are the benefits of it? And so I think, the only way the control thesis works is if you say like, well, what is the problem that states are trying to overcome? So we think here is really the backlash. And I think that leads both to the formality aspect or the informality and the like ability to get out of these treaties easily if there's a backlash, and also the obfuscation because you're trying to prevent a backlash. So I think we can be clear about that. Yeah, you're right. We should state and see the sending state and test it on that side too. And we have looked, so it's not that immigration isn't necessarily popular, because if you look at like immigration is actually fairly popular in the US right now. It's that like for a small group of people, they really don't like it and it's a really important issue to them. So the salience is really high. But I think if you look back, I mean, if we think back to the 1950s and 60s, I'm not sure that like that was a particular time where like Europeans were really in love with immigration. I think they just weren't worried about it in the same way. And then you see that's when we have the most formalization of these treaties. You actually have these things submitted to the UN treaty series. They're called treaties. Like it's much more formal. So that's in there. You're right. All these points about what is actually in the data set and what we can find are great ones for our methodology. And then I'll just say on like these questions of like, what do we mean by treaties and what do we mean by informality? Yeah, we're political scientists. We don't like do definitions as much as you lawyers do in this sense, but you're right. We need to better define that, but we only think about defining these things once we have to measure them. We're not as like precise about them as lawyers are, because that's just not our training. Tiana, did you want to add in?
Yeah, just to add on that point, like I think that Timur's paper will probably help us to like specify on that as well, to be honest.
Thank you. So let's take questions. So Piasiri.
Okay, thank you. Yes, first of all, let me again congratulate the authors for collating this important data. Now, again, I'm also like the discussant. I'm not a lawyer, but let me first start with this question the discussion raised about IOM and data. Actually, this IOM, yes, which is advertising itself as the UN Migration Agency, which is completely wrong because it's not an agency, it's an organization, and also it is very loosely affiliated to the UN as a affiliated organization like the WTO and others. So when it says the UN agency, it's a different story. Anyway, when we did this global review for the ILO in 2014-15, we collected about the text. We identified about 350 agreements, plus agreements, but only got text for about 156 agreements. And then, of course, some of these were made available by countries on the condition that they cannot be released. They cannot be in the public domain. So the ILO had a request from its tripartite partners from the meeting to have a repository of bilateral labor agreements. So what ILO did is they posted about 80 plus, 80, I don't remember, 87 or 88 of these on their website. But the rest they could not touch because the conditions of confidentiality. Like the quotation I gave, because I saw that agreement in a ministry office, just asked me to look at it, not even, take a copy or write down it. Anyway, now coming to the issue about the informalization, yes, and this is related to the earlier discussion also. Now, in our research, actually, Marius also in Southern Africa, we find that there is now countries like South Africa and others want to go more for MOUs rather than BLS, although they traditionally like it. But I have a question here. Now, the issue is that most global migration movements take place outside bilateral labor agreements, as far as my knowledge goes. So the countries like, UK, USA, Canada, Australia, they all follow unilateral policies. They decide, who should be admitted, what quotas to be given. So, I mean, therefore, I find it a little difficult to buy this argument that, informalization, these countries, of course, want to control migration very much. These are, especially UK. I mean, that's one of the worst migration governance systems now. I mean, with Brexit and others. So, of course, migration is part of street politics. I mean, Trump was a very good example of, showing this. So, is bilateral labor agreements, so MOUs, an instrument for migration control? I mean, if it is, of course, then there is a argument for, using them and also keeping them hidden. But the problem is, if countries want to keep their policies, migration policies secret, I mean, they have to be more worried about the media, because the media is the one which, really exaggerate, whether the countries are, controlling migration or, the governments, every government wants to show that migration is under control. But if you look at UK media and others, you find that, it is the media which is really exaggerating these other things. So I think agreements as such, whether they are formal law, getting informal place, in my personal opinion, it does not play a major role here. Now take the example of, Asia, I'm quite familiar. Now Japan resisted migration for a long time. Now they opened up and they have what is called MCOs, Memorandum of Cooperation, signing with a number of countries. Republic of Korea, until 2004, they only had trainee programs, but then they introduced this system. They have MOUs with 15 countries. But all these are known, I mean, because the quotas are known. But most of these agreements, I mean, if your argument is, if I understood it correctly, if the agreements mention admitting hundreds of thousands workers and others, then of course it makes sense to keep them secret. But in most cases, they don't mention any numbers. The most of the bilateral numbers don't contain, quotas and other things. Only in a special, like a South Korean case, government-to-government agreement, they admit from 15 countries about 80,000 maximum. It is a very small number when you divide it over 15 countries. So that is the okay. Sorry, I'm taking too much time. I will stop there. Yeah.
Thank you. Thank you very much. Let's take also Adam now and then get responses. So Adam.
Thanks. So I had, first, it's great that you're taking advantage of the great data that Maggie had already collected to research this question. I think it's very cool use. I had three empirical, suggestions or questions. So the first is on selection, which is, so not only, even though Maggie's data is currently the most comprehensive data that's around on BLAs, it's still, I think we all think, incomplete. And so you're starting with, we don't know all of the treaties. But then on top of that, by the time that you get to table 1 for the regressions, you're down to, I can't remember now, I don't have them right in front of me, but like 100 agreements or something like that, or 200 agreements, just sort of a fraction of the data set, which is, obviously already incomplete. So it makes it weird to think about just understanding what a statistically significant result means with 150 treaties out of a 700 treaty data set. And so, for instance, one thing that you might want to do is even just show summary statistics that compare the sample to the overall universe of Maggie's data, like the size of the country or the GDP or whatever, so you can get a sense of these. Is the sample now more Asian countries or is it more European countries or what have you? So that, sort of selection issue is concerning. Relatedly, you don't hold the sample fixed for the different specifications in tables 1 and 2. So the sort of the sample size changes as the model changes based on data availability. But the complication then is it's tough to know whether or not the differences in the results for the different columns are due to the changes in the variables that you're including or the changes in the sample. So it might be useful to just use whatever it's the data set that you have the complete data for, like a fixed sample across the different specifications so that it's not changing specification to specification. All right, so that's on selection. Second, on multicollinearity, which is just to say, you have a bunch of hypotheses, they all seem plausible, but you have these regressions that test these all simultaneously. And it's tough to know whether or not the lack of significant results for some of the hypotheses are due to the hypotheses not being valid, or because you have these 10 different variables that measure things that might all be correlated, that makes it so that no individual variable is like popping out. So you might want to run a regression where you just take one of the hypotheses at a time and test it by itself 3 different ways and then test the next hypothesis, et cetera, instead of these what are sometimes called in an impolite way, garbage can regressions, where you've thrown everything in at once to see what comes out. All right, third point. The third point relates to what was already brought up in the discussion, but is the validity of the Google measure, which, by the way, is very clever. I have not seen someone do that before, just how long it took us to find it in search. On that, one thought is whether or not you could take some sample of treaties that exists and that is sort of similarly available, and like one treaty from Thailand and one treaty from France that you're positive exist, and see if you can find them in similar amounts of time. But if there's like a big difference using your method of how long it takes to find them, then maybe the measure is biased in the ways that were already mentioned. The other thought, though, is there must be measurement error with this dependent variable that's pretty big. And when you have measurement error on the dependent variable, it inflates all of the standard errors. I think that's exactly what we see in your table, where you have these coefficients that are reasonably large for some of your hypotheses, but then the standard errors are just so huge that the results aren't significant. And so it's possible that you're right on many of these hypotheses, and it's just the measurement error in the data makes it tough to identify a statistically significant effect. I'm not sure what to do about that, to find ways to try to tighten up the measurement error on this variable. But it at least wouldn't lead me to reject or to rule out some of these hypotheses that you're laid out that still seem plausible. All right, I'll stop there.
Thank you. So we have 3 minutes for you to respond.
Should I start?
Sure, you want to start?
Yeah, so thank you for the comments. So maybe just to kind of talk about how I researched for the agreements a little bit more, because PS3, I think, talked about the ILO repository. I took Maggie's list the title and then ran a Google search, sometimes just putting in country A, country B, and then the year plus title to see what would kind of pop out. And most of the time I could immediately find the agreement text. Most of the time, the times where there is an agreement with the UN treaty series, the agreement text is easily accessible. And then for most cases in our data set, it's not. The ILO agreements repository actually was a good tool, and most of the agreements where we could find an agreement text are from there, to be honest, because that was probably like the kickoff from your ILO study that made it like more accessible for us now, possibly, which is kind of interesting. And then on informalization overall, as opposed to, well, countries tend to like act unilaterally, and bilateralism is kind of becoming a diplomatic tool more than really governing migration control. Possibly, but then why informalize, or why keep them secret at some point, I suppose. I'll have to think more about that, but I thought that was kind of a good question that I should think about more. On the empirical, we also have to run robustness checks. We haven't done that yet, and every point is spot on, so we'll have to. The results still have to be fleshed out more, as well as the conclusion. That's kind of where we're at now.
Yeah, those our results were sort of like the first pass at it, and so we'll have to think more about what else we can do, and thinking more about the selection issue that we honestly didn't spend as much time thinking about. And but sorry, I agree that like the question of BLMs, and especially thinking like from a US or very often, of course, is like, why bother? So that's if you're interested, that was the paper that I wrote in 2019 was sort of like getting at the why bother question of like, why do states even bother to sign these things, especially since they're giving up control, and we know that states don't like to give up control for various things. And so I think that's a good point. And then it's just interesting, I'd love to back channel with you at some point. It'd be great if you could tell us which countries were not willing to like let the ILL have their have their treaty in the data set or like have it published, because that would be really interesting. But I'm guessing you can't tell us that. But thank you again to everybody for your great comments and thoughts.
Thank you very, very much, Tiana and Maggie and Janie, for this great exchange, and everybody else who participated. This was our last panel. So this was a tour de force, I think, the last couple of hours, but we do ask for 10 to 15 more minutes of your time just to sum up what we've done here, and to really kind of wrap up, and then hear from Yasmin from Theoretical Inquiries in Law about our next steps. So I made this somewhat scary mind map of what we've been doing here. So, all of us have been Zooming too much. It's absolutely clear. And this is the evidence of me teaching too much on Zoom. So I'm not going to walk you through all of it, but I just want to kind of highlight some themes that came up and that maybe some of you would want to highlight more in your papers as you continue writing them, because I think the conversations that we had here were really meaningful. So we all agree that BLAs are on the rise and are increasingly used as a tool for migration governance, or as Marianne helpfully pointed out in one of her comments yesterday, maybe just migration management and not migration governance. I think another interesting point we need to think about. And as Adam and Bartok opened with, we're still figuring out what exactly is and isn't in them. And I think their project is going to be amazingly useful for all of us as they continue their coding. And indeed, we're still working out both their content of BLAs and their outcomes and impact, and trying to understand what do BLAs do. And a question that was at the background or foreground of many papers here was, do BLAs improve migrant workers' rights? And I think we all kind of think the answer is no. Ayushman's paper showed us how discourse around BLAs in Nepal is that of workers' rights, but how the same discourse causes entrapment and vulnerability. It's not BLAs, but it is the discourse around them. Jenna and Harry's and Nicola's paper revealed the extent to which BLAs are not sensitive to gender issues and do not offer any protection to women migrants. And Yahel, in her response to them, showed us how BLAs are not only just blind to gender, but in fact can entrench vulnerabilities. The example she gave us was randomizing placement of migrant workers, which individualized placement processes and reduced community and familial protection for women. And of course, Rebecca and Susanna alluded to core rights that needed to be protected, but even those core rights, were kind of like, okay, we still don't know exactly what they are, right? That was debatable. Which ones do we think BLAs should and can promote? We don't know that from looking at BLAs currently. And of course, there's a question, the related question, and there you see this line, why do countries enter BLAs? Maggie just discussed this. Maggie's really important paper deals with this. And of course, Chilton, Adam and Richard's Posner's. But they still give us partial answers, right? That's a question that's, again, where a lot of us are really dealing with. If we're not sure they protect workers' rights, we actually don't know the increased migration or remittances. And again, another paper by Adam and Bartok, or we don't even know that they open new migration corridors, actually. So Yuval and I searching for protection rights and not for protection and rights are not finding them. We put forward the control thesis that we presented, and we suggested that this actually may be a shared interest in controlling migrants and the recruitment industry. And we also thought maybe we need to pay more attention to the role of sending countries. And we were also looking in this kind of for the explanation of secrecy and unbindingness. Another issue that really came up strongly, I think, in all of our conversations was the power asymmetry, right? The power relations. Why do countries enter BLAs? Well, we need to really think about the power dynamics here. Who gets to set what? Sending countries versus receiving countries, south versus north, and what's happening at south to south migration. We heard at the very interesting talk today by Sudarat. And Yahel and Abinam actually suggested that to understand BLAs, we really need to look at the processes of their institutionalization and their processes of institutionalization that they generate themselves. And here we also, of course, had the Jennifer Gordon's paper that led us to the interest of corporations, and I'll say a little bit more about that in a second. But let's hop to the other side here to issues of recruitment. So what do BLAs do? It turns out, I think most of us agree that they are possibly pretty good at regulating recruitment and making that better. And we saw Rebecca and Nona today showing us that BLAs can address vulnerabilities in recruitment. At least the Israeli case shows that very strongly. And it really appears from our discussion that if BLAs are good at anything, it's about managing recruitment and reducing the cost of migration and creation of debt to migrants. But does that have to be via G2G arrangements? What is the role of private recruitment industry here? And here we had this really interesting exchange with Rebecca and Susanna from LAMP sharing with us their vision of the role of BLAs in creating quality recruitment private industry. And we had some pushback in the room from Jennifer and others whether the problems are really ones of transaction costs and information rather than structural and emanating from power relations, thus requiring us to rethink of how to redesign markets to level the playing field and restructure markets so that businesses will turn to fair recruitment. And can BLAs be part of that process, right? We see actually the Israeli case showed us it might, but it wasn't very good at other things. And of course, Jennifer in her own paper about free trade zone emphasized the role of corporate interests, and corporate interests are also intermediaries, corporate interest, right? It's also producers and lead firms, etc. And Jennifer helped us understand that free trade zones are creating this double labor arbitrage for corporations, nudging us to look beyond government interest to explore corporate and private market ones. And Jennifer also allowed us to rethink the narratives of free trade zones and labor management. And I think we can take that to think about governance tools as either borders, limiting movement, or as a gift, a human rights tool. And of course, we have the question of characteristics. That's what we ended up with today. Tamar in her paper explored the question of whether BLAs are legitimate tools of governance if they are secret and non-binding. Took her through a fascinating journey in international law to explore the meaning of the secrecy. And Maggie and Tiana suggested that maybe the informality and obfuscation in BLAs stems from immigration being a hot and controversial topic, and that political actors and policymakers prefer this informality, and maybe it's even better for migrant workers, right? So that also kind of takes us in another direction of whether we want to fight this informality or not. And of course, there's a question of scale of governance, right? That also lingered all the time. What is the level of governance? Is bilateral the right level of governance to govern all of this versus the national versus the multilateral? And then finally, we had methods. We had so many methods. We had coding, right? So many of us are doing some form of coding exercises, trying to kind of quantitatively understand what's happening here. And I think there is a call here for a shared BLAs archive, and I'm gonna try and push that forward once I recover from the conference. And of course, we have qualitative, we have interviews with so many different actors, and we have participatory action research that Ayushman brought to the table. And we have case studies, right? All these different case studies. We had many of them. We had the Israeli one again and again, but we had others as well, and the Nepali one. And we had Rebecca and Susanna offering several of them. And then comparing case studies, right? Marian's looking at France and the Swiss example. How do we compare? And of course, there was also the comparison of construction versus agriculture today, right? We have also sectoral comparison that can be challenging on its own. And then we have institutional analysis, it's another tool. And then there are, of course, BSAs, right? We had Marius talking about them, but why do we know so little about them? And how come they're not integrated into BLAs? And there are other issues that I didn't go into, but these are kind of, I think, issues that a lot of us dealt with, and that I think will really be kind of the themes, at least the larger circles you see here will be the theme of this volume. So this is just kind of, to give you some a way of kind of putting together a lot of what we try to do here in these 3 days. I also really want to thank, I don't know if they're still with us, I'm going to stop sharing, but I really want to thank the guests who were with us this whole time very patiently. Ellen Hyde and Arwen Joyce and Pia Siri, and Michael Wabel and Fabiola Miras and Shachal Shoam and Mayan Yezne, who are just hanging out with us and giving us really great comments and feedback. So thank you so much for that as well. It's really appreciated, especially when it's on Zoom. Thank you very much for that. So I think I am gonna end with that. I don't know if Adam or Tamal, if you want to say something briefly before we move to Yasmin.
Huge thank you to everyone. It was really a delight.
I just want to say thanks to Hila and Tamar for making this happen. They had the goal of promoting research on BLAs and creating a community of people that did that. In spite of a pandemic and other setbacks, I think they've extremely succeeded, and it's just fantastic that they did this. I'm very grateful. Thank you so much.
Thank you. Yasmin, to you.
Hello. So thanks to everyone. It was a very, very fascinating conference. And yeah, it's going to be our job now to transform these fantastic papers into an even better volume of published articles. And so basically, I don't even have that much to say at this stage. So even, I guess, probably even tomorrow or in 2 days, we're going to send you a letter with the most important deadlines you have to meet and some technical details about the articles as to word count and abstracts and formatting guidelines. So at this point, I would just like to highlight the most important deadlines and give you the opportunity to ask any questions concerning the editing process, in case there are any. Hila, can you enable me to share my screen?
I just did.
Yeah.
Oh, okay. So okay. So what we can see here, that's the expected timetable for the publishing, and I highlighted the dates which are most important for you to note in yellow. So basically, what's going to happen now after the conference, we're going to ask our student editors to transcribe like all the comments and questions and answers that have been discussed throughout this conference. And we're going to send this to you in a compromised document by the end of July. That might be helpful for you in editing the article, but it's up to you how you wish to use this. And we're also going to add some very, very initial comments of our editorial report, which is only, but it's not considered any kind of substantial editing at this stage. So, and then there was until September 1st, we need to receive the final articles, and then we're going to start our editing process, which is hopefully going to be finished by the end of December, and then we're going to send you back the articles together with all of our comments, which are normally contained in the Word document. We put them in the bubbles on the side, and we'll also send you an accompanying letter with some more general remarks. And then you're probably going to have about another 2 months to revise the article until February 1st. And from then onwards, there's going to be a back and forth of small changes, small revisions, and some others, small suggestions from us, from our stylistic editor, from our graphics. So, but an important date to note is going to be like mid-May, May 15th, which is basically the deadline after which we cannot accept any more changes. So the most substantial changes need to happen until February 1st. And then we can only, we're going to go over the articles once more and to give you the opportunity to incorporate some further small changes. But by May 15th, this is not going to be possible anymore. And then there's only going to be formatting and graphics and galleys and proofreading. So that's for now. And then in July, there's going to be the online publishing, and also there's also going to be a print version, and you will receive an example. And it's important to know that these deadlines, our students are all very, very busy with their studies, with exams, and we try to build the schedule in a way so that it's possible for us to nevertheless do our very best to give you the best possible editing. But it's important that you try to meet these deadlines. We understand that this is not always possible. There can be all kinds of obstacles and issues. In this case, please talk to us so we can try to take this into consideration. But it's going to be a problem for us if these deadlines are exceeded significantly, just because of exam terms and the study obligations we all have. So yeah, that's basically for now. I'm going to be available all the time. You can always contact me and ask questions, and it's important for us to be in touch and to work with you closely on the articles. It's not, we want to do this together and so that everybody feels that they publish the article in the best possible way and they would like to do it. So I'm always here for any kind of question or comment. And yeah, in case you have any question, I'm also happy to answer.
Thank you, Yasmin. Does anybody have any questions about the process at the moment?
So we're also gonna, so you don't need to memorize this now. We're gonna send you also with the emails, always a reminder.
Not to worry, nobody's gonna memorize.
No. It's gonna be fine. Like even if it's confusing.
Thank you very, very much, Yasmin. We all look forward to working with you and with the team of editors who are also with us, many of them throughout. So thank you guys too. And yeah, so that's it. We're done. I will say, just so all of you will be jealous, that some of us who are in Tel Aviv are going to go out for drinks now. So just so you know, if you were here, we would do this together, but you're not. So next time, I owe you a drink. Thank you again, and we'll be in touch. Good night.
Thank you all so much. Thanks, Hila.
Thank you. Thank you so much.
Thanks. Great comments.
Thank you. Thank you so much for organizing.
Sure, thank you.
Thanks a lot.
Thanks.